right, good evening, folks. Welcome to Monday Night Law here at Kirk's Law Corner. This is February 12th, 2024. All right, well, I'm going to start off tonight with a little bit of discussion on a debacle that we had yesterday out there on X. There seems to be a little confusion on dealing with the subject matter of migration or immigration. And I made a comment on this man's post that it was false that the Congress doesn't have any authority over immigration and that kind of stuff. And I'm like, well, no. And I, quick post, bam, right there, Article 1, Section 9. But it's much deeper than that. And so I wanted to cover that first, and then we'll get into the Blackstone's Commentaries on the Law of England. Back to where we left off last week. So without further ado, Dazel D's, good to see you, brother. So I have to go down here to... This is what I posted here. I said it was false. And I don't know where the original one was. Let's see if I can find the original post. Get that cleared. Hi, CC from Alaska. James, good evening, James. Hello, everybody out there on Telegram and Rumble and X and YouTube and Facebook. And, of course, again, Telegram. Well, anyways, so we're going to go into that right there is what I said was that it was false that Congress has the authority, delegated authority over, right there, the migration or importation of such persons as any of these states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax duty may be imposed on such importation. I had to cut the last part of that off because it wouldn't fit. But, he wanted to argue with me that I didn't even know what this says. So, unfortunately, I don't understand why this man wants to argue with me when it's the facts of letter of law, and he's trying to say I'm not comprehending it correctly. So... he wouldn't allow me to speak. He always just talked over me on his little space thing, which I think spaces are just a joke over there. But I prefer going live like this where I can screen share, way we've been doing this for years, and where I can broadcast on, 5 different platforms at the same time. So before we get into Article 1, Section 9, which is the limits on the legislative power, which is federal. Section 10 is limits on the states. Now, somebody else posted out there, oh yeah, the 9th and the 10th Amendment. Yeah, let's read that. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So, what I'm gonna expose here is the fact that the truth, the reality, and letter of the law of the land, as supreme law of the land, as it is written. I didn't write it, and it's not my opinion. We'll go to some opinions on it here in a bit. So the fact is that the powers that are not delegated to the United States, nor prohibited to the states, are reserved to the states. I get that. So I think there's some confusion on the words because, reading means reading, and words have meanings. So keep this in mind. If the power is delegated to Congress, to the federal government, then the states cannot. They do not have what's called subject matter jurisdiction. Okay? Now this is where we're going to get into this part right here, where he posts this case here. Persons are not subjects of commerce and not being imported goods. They do not fall within the reasoning founded upon the constructive power given to Congress to regulate commerce, and the prohibition of the states from imposing a duty on imported goods. Okay, the argument was that this was about commerce, but it's not, as we will see when we read the Constitution. And then this is another problem people have out there that I was guilty of this myself many, many years ago. But the fact is you have to read all of it. And this is cherry picking is what this is picking what he thinks applies to him in his argument to support his argument. But the reality here is you got to continue reading. That a state has the same undeniable and unlimited jurisdiction over all persons and things within its territorial limits as any, and so that's where he stops, as any foreign nation where that jurisdiction is not surrendered or restrained by the Constitution of the United States, which the 10th Amendment reaffirms that, right? That by virtue of this, it is not only the right but the burden and solemn duty of a state to advance the safety, happiness, and prosperity of its people, and to provide for its general welfare by any and every act of legislation which it may deem to be conducive to these ends, where the power over the particular subject, that's right, I can't highlight, subject, see, this is called subject matter jurisdiction. Here's your word jurisdiction, here's your word subject. So this is called subject matter jurisdiction, or the manner of its exercise is not surrendered or restrained in the manner just stated, as in to the United States. Okay? So let's go look at the Constitution again and see what it actually says as it is written. Now, Article 1, Section 9 is clear. And the reality of this is the words, subject matter. Okay, this is the subject matter. The migration. What is migration? Let's go to etymology, because I love to use etymology first, before any kind of law dictionary, because etymology is origin of the words themselves. It doesn't use case law. That's something that people don't realize, is that like Black's Law Dictionary is all case law from the Roman civil law and the bar code. So, which is one reason why I like the Bouvet's Law Dictionary 1856, because that's for America. If you read the full title of the book, of the Law Dictionary, it's curtailed for the United States of America. But what is migration? Change of residence or habitat, removal or transfer from one locality to another, especially at a distance. From the 1610s, that word migration was created, or where this is coming from. Of persons, 1640s of animals, and then it gets into the Latin, right? Because English language is not the original language. A lot of this stuff was written in. It was written in Latin and then Greek, and then from Greek into English. So now that we kind of have a basic understanding, but a removal, change of abode, migration, noun of action from past participle, blah, 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 to move from one place to another. Probably originally, which is an extended form of root of MEI. To change, go, move. Okay, so now that we know what migration is it's basically moving, and the very first part of this is the change of residence. Okay? And this goes back to the Law of Nations. Book 1, Chapter 19, subsection 213, about inhabitants and having to declare their intent to settle there. Hey, Mark. Good to see you, brother. Gen G out here on YouTube. Courts ignore their lack of subject matter jurisdiction and proceed with cases anyway, in my experience. Well, where are you doing the paperwork to challenge it? So a lot of people think they can just say, well, I'm challenging jurisdiction and try to speak it. Got to do it on paper. Proper form. Mark, why does the A091 form say district court on it? Because district court is the trial court. It's the only trial court. Now, the next word there is or, and then importation. Now, we'll go to importation. This just goes back to what was actually going on back then and why they were prohibited. Why was Congress prohibited because this is Article 1, Section 9 is prohibition, right? So in order to prohibit Congress prior to the year 1808, wouldn't they already have to have the power to prohibit? That's the thing. Okay, so what we're doing is we're focusing on, like a microscope at 100 times focus here. Now let's back out and let's look at Article 1 as a whole, right? Because Article 1 itself is the entire legislative branch. So all of Article 1 has to do with the legislative branch. Article 1, Section 9 and 10, right? 9 is part of Article 1. But let's look at Section 8, the scope of the legislative power. This is where it's actually enumerated, the power to regulate that. But see, you have to understand the words, and it's Article 1, Section 8, Clause 4. It's to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcy throughout the United States. But the key part is to establish a uniform rule of naturalization. This is a delegation of power to Congress. Article 1, legislative branch, federal. So this is where it says they actually have the power. Then this power is prohibited until 1808. Okay? They cannot prohibit migration or importation of persons known as slaves because they were trying to abolish the slavery, slave trade, the whole 9 yards, even clear back to the first Constitution, at least the draft Constitution of Virginia, 1776. So, but naturalization isn't migration. Yes, actually it is, as we just covered under etymology prior to. Act of naturalizing, state of being naturalized. Specifically in reference to the act of receiving an alien into the condition of a natural citizen. Oh. So this is where the power is delegated to Congress. So this means that's prohibited to the states. See the 10th Amendment. This isn't commerce. This is naturalization or migration, also known as immigration. Okay? No, naturalization is immigration. Right? Etymology, because words have meanings. Change of residence or habitat, removal or transit from one locality to another. That's migration. Now, and you have to be naturalized. Yeah, we're going to get into that. Because when you get into the overview, right, and I'll show you how I get to that so you have a better understanding of what I'm getting at. This is called the Annotated Constitution. Okay? Article 1, Section 8, see explanation. We're going to go, I'm going to have to go back. Pardon me. See explanation. They get to explain this, right? And we're going to go down to that particular part regarding naturalization. Overview of naturalization clause. Article 1, Section 8, Clause 4 of the Constitution provides Congress with the power to establish uniform rule of naturalization throughout the United States. The Supreme Court has described naturalization as the act of adopting a foreigner and clothing him with the privileges of a native citizen. Wow, that goes right back to etymology, origin of the word itself. Okay? Pursuant to this authority, Congress may legislate terms and conditions by which a foreign-born national alien may become a U.S. citizen. Moreover, Congress's power over naturalization is exclusive. States may not impose their own terms and conditions by which aliens may become U.S. citizens. Ha! Based on this broad power, Congress has enacted a series of laws governing the naturalization of aliens in the United States since the end of the 18th century. These naturalization laws have generally applied to three main categories of aliens. One, those who have resided in the United States for certain periods of time and applied for naturalization. That's the contract. Got to have a contract to come here. Those born abroad to U.S. citizen parents, and those who derive citizenship of their parents naturalized in the United States. Congress's power under the naturalization clauses is not limited to conferring citizenship. The Supreme Court has recognized the power is also given Congress the ability to revoke citizenship improperly obtained through fraud or other unlawful means. Additionally, the Court has recognized that Congress has the power to expatriate an individual who, through some voluntary act, has relinquished his or her U.S. citizenship. In addition to conferring Congress the power to determine when foreign nationals may obtain U.S. citizenship, the naturalization clause sometimes viewed as contributing to Congress's power over immigration, including its power to set rules for when aliens may enter or remain in the United States. Congress's implied power over immigration is explained in the discussion of the Necessary and Proper Clause under Article 1, Section 8, Clause 18 of the Constitution. Now, I want to get into that part there, 1, 2, and 3 cases. So this has gone to the courts. This is old. Some of this is old stuff. 1892, 1824. Naturalized citizen becomes a member of the society, possessing all the rights of a native citizen, standing in the view of the Constitution on the footing of a native. Then it's superseded by a statute. So they made the statutes. Okay, that's where that delegation of power is, to make statutes. Okay. I just said what I was taught last night. That's funny because I've been at this for about 29 years, dude. You're new here. Footnote number 3. Noting that the rights of a naturalized citizen derive from the requirements set by Congress. The federal government has a broad constitutional power to determine what aliens shall be admitted to the United States, the period they may remain, regulation of their conduct before naturalization, and the terms and conditions of their naturalization. Recognizing that the naturalization power strictly applies to persons born in a foreign country under a foreign government. So, here's the thing. Well, let's do the next one before I go into this. Under the Constitution, the states are granted no such powers. They can neither add to nor take from the conditions lawfully imposed by Congress upon admission, naturalization, and residence of aliens in the United States or the several states. Okay? Makes it pretty clear here that Congress is the one that has the power over this. States do not. Now, see, this is where I think the confusion is on what's going on with the border. It's not migration. It's not an immigration. That is an invasion. They're not coming in lawfully. They're not following Congress's statutes or regulations regarding coming into our country and our nation. That's the key, okay? Subject matter jurisdiction. We're going to change the subject matter. Now we're going to get into Article 4. What is in Article 4? Oh, it would be the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion. Wait, is this a power being set to the federal government? And on application of the legislature. Now pay attention, folks. My longtime followers already know about the right to petition, sometimes referred to as the First Amendment. But read your state constitutions. It's the right to petition the legislature for the redress of grievances, the right to peaceably assemble and consult for our common good, and instruct our representatives. That's a petition. Okay? It's a political lawsuit. Or of the executive when the legislature cannot be convened against domestic violence. Now, here's the key. This is a political argument, not a judicial one. For a lot of you out there that's been following me for a while, this is a repeat for you. But for those that are new, that are just tuning in, do not quite understand Article 4, Section 4, and due process of law, because this is supreme law of the land, which literally means due process of law. For those who have been following me for, 6 years, you already know this. The hysterical background, right? This is where we get into that Article 4 is generally known as the Guarantee Clause. Through its terms, the United States makes 3 related assurances to the states. Guarantee of Republican form of government. Wait a minute. So if you don't have a Republican form of government in your state, you're supposed to petition Congress for the redress of grievances, not the judicial. Number 2, protection against foreign invasion. See, here's that subject matter jurisdiction again. And then number 3, upon request by the state, protection against internal insurrection or rebellion. That's the domestic violence. Domestic violence means internal insurrection. Internal, which actually means an attempt to overthrow the Constitution, the laws of its creation, government, because that's what a constitution is. It is the instrument of government itself. It creates government. Okay? And it is the conscience of all of the persons created, because that's the root of the word constitution, is conscience. See, government is the figment of our imaginations. We take those figments and we put them down on paper. This is created by man. It's not created by God, it's created by man. Earlier version of the Guarantee Clause resolutions, the Virginia Plan, introduced in the Constitutional Convention and attributed to James Madison. The resolution went through several formulations during the debates in the convention. During a key debate, Governor Morris objected to the resolution because he should be very unwilling that such laws as exist in Rhode Island ought to be guaranteed. Randolph explained that rather than cementing the existing laws of the states, the resolution had 2 objects: to secure Republican government, to suppress domestic commotions, along with concerns about rebellions. Delegates expressed fears that a monarchy might arise in a particular state and establish a tyranny over the whole United States. That is the big part of that. Okay? So, now, the next part is moved to substitute the language that the constitutional authority of the state shall be guaranteed to them respectively against domestic as well as foreign violence. Okay? So, this is right here. This is delegated power, and it specifically states that this goes to Congress, legislative branch. This is federal constitution. In Luther versus Borden, the Supreme Court in 1849 held that questions arising under the Guarantee Clause are generally political and not judicial in character. What that means is the judicial branch does not have subject matter jurisdiction over invasion. Okay? They don't have subject matter jurisdiction over domestic violence. They do not have subject matter jurisdiction over Republican form of government. Now, where the confusion I think is coming from on this invasion stuff is because there are powers that are still retained by the states. But that's a different section. That's Article 1, Section 10. No state shall, without the consent of Congress, lay any duty or tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. Now, that is the power. This is, again, under prohibitions to the states, and this is the exception to this prohibition, unless actually invaded. This is a foreign invasion. That is the proper subject matter jurisdiction. Because words have meanings. This is not a migration. This is an invasion. Okay? We don't have open borders. And this comes from the fundamental principle of we have the right to defend our own personal property, so therefore we can delegate that power to state or federal to ensure that our property is defended. And if you want to get into like military law and under admiralty jurisdiction, technically speaking, the military has jurisdiction 100 miles from the border, all the way around. The military, see, this is where the Second Amendment comes in, that a well-regulated militia being necessary for the security of a free state. That's right. Military is supposed to be securing the borders, not this shit made up of Border Patrol and Homeland Security. Those are all, three-letter agencies or whatever, unlawfully created agencies. A militia being necessary, a well-regulated militia being necessary for the security of a free state. That's the law. We're not supposed to have any other armed bodies of men. These policy officers. That's this comes from history. But the king back in the day there created that, and that's what our founders were talking about, no armed bodies of men, and that erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance, is exactly what they were talking about. These policy officers. Okay? So we're supposed to have a military, a militia. Let's see, where was it? Okay, so that was Article 1, Section 10. Where else was it? I think that's pretty much it. That should clarify the difference between immigration, which Congress has the power to prohibit, because we just covered the annotated Constitution. That's already gone through the judicial branch. It's already been discussed. Several opinions all throughout history, even far back as 1812. So that argument is moot. Facts of law and a discussion on that has already been had. Subject matter jurisdiction belongs to Congress regarding migration, which means people coming in here to settle. But you can also go to the Law of Nations and read the same thing. Okay? You have to declare your status. That you intend, well, it's not status, declare that your intent to settle here. And it does talk about that when the child becomes of age, it is up for him to choose whether he wants to remain a citizen or not. He has to declare his status. So declarations, right? So, if he would have let me speak the very first part of that, because I didn't expand his original post, I just saw the very first part of it there. And I was going to explain to him what I just explained here, was that there's a clear distinction between migration and invasion. This is, in fact, an invasion. My brother Jonathan Alexander Townsend and some other people down there that I met when I was down there in October in Arizona, down there for Constitution Week and down on the border stuff. These guys are literally on the border themselves, and they're putting their life in harm's way right now, trying to defend a man's property from these cartel that are coming on his land and destroying, water pipelines and stuff like that. We have the right to do that because that's a right retained by the people, because the militia is composed of the body of the people themselves. Now, there's something going on here in Congress who's trying to shut that down. Congress has this bill going through preventing private paramilitary activity. Well, you don't have subject matter jurisdiction over that, because the right of the people to keep and bear arms shall not be infringed. And we have the right to peaceably assemble. We have the right of self-defense. In the New York State Rifle Pistol Association versus Bruin, June of 2022 there, they already made that ruling. And went all the way back to Blackstone's Commentaries on the Law of England, which is what I've been covering for the last, now, 8 weeks, because it's such a good read and getting into these absolute right of self-defense. That's what they cited. It comes from the laws of nature. So, just exactly how does Congress have the authority, subject matter jurisdiction, to even create this act? And then I'm going to expose that this is not a real statute. What I've been trying to tell you people, this is all Roman civil law, the code. What does it say? To amend Title 18 United States Code to prohibit unauthorized private paramilitary activity for the other purposes. No. Why are you making amendments to the code? Where's the statute? Huh. They don't want us to be able to defend ourselves. Well, I can tell you right now, the Supreme Court's already put the kibosh on. There was somebody out here last week was saying something about that there was a case out there that the Supreme Court abolished that felons can't own arms. All right, brother Diesel D's, I see you over here. You got a question, brother? Here, let me see. Diesel D's over on Telegram. I know you like to bounce around. You have to unmute yourself, Diesel D's, on Telegram. All right. So, again, just exposing this right here is the fact that they're making amendments to the code. Where's the statute? This is what they've been doing for a long time,
Hello?
folks. Yo, Diesel D's, what's up, brother?
Hello.
You're unmuted, bro. What, did you have a question? Diesel D's. All right. Might be having a connection issue over there. Absolutely, Mark. Felons can, as long as they already paid their debt to society. That's the thing. I found that literally in the Criminal Practice Act of 1864 here for Idaho, that it says when you're done with your sentence, you do your time and stuff, you get all of your rights back, all of them. So I mean, we have to stick with the fundamental principle here. Do they have the authority to prohibit a right? Not just the Second Amendment, but any right. So we have to establish a principle. The fact is no. Like it's already been said by Supreme Court, well, you don't have the authority to make legislation regarding due process of law, or a right to remain silent, or any other rights. That was the question the Supreme Court asked these guys. Well, do you have subject matter jurisdiction? No. If you got a question, put it in the chat. I was gonna let Diesel D's talk because I actually know him personally, so I'm okay with that one, with Diesel D's. So, but everybody else, please put your questions in the comment section over there on, if you're on Telegram or on YouTube, whatever. So I just wanted to make people aware of this, that this is what they're trying to push. But this is a perfect example of what a remonstrance would be used for, not a petition. This is in the middle of legislation that's happening right now. And you would remonstrate, which again is a formal written protest. It is a declaration. You're protesting against this because. And remonstrances do not have a prayer for relief. Okay? So the remonstrance would go in and say, hey, you don't have this authority because you don't have subject matter jurisdiction. I am opposed to this legislation because, and give the reasons why you're opposed to this and why you are protesting this. Okay? Congress does not have subject matter jurisdiction over any of our rights. And that's essentially, if you read that New York State Rifle Pistol Association versus Bruin, they hash that out. They don't have any subject matter jurisdiction over any of our rights unless, the well-regulated part of the militia. Yeah, that's federal militia, military, or state militia, military, which is what, those are the only lawful armed bodies of men. But they do not have the authority of the militia themselves. So they're trying hard. Okay? But no. Trying to get rid of large capacity ammunition, or I don't know what they're trying to really do. Oh, a dangerous weapon. But see, and then you use the word firearm. No, it's not called a firearm, it's just called arms. Okay? There's no such thing as a dangerous weapon. I mean, that could be totally misconstrued it could be a frickin' car. It could be a lawn dart. It could be a frisbee. It could be a pocket knife. Okay, so the question is, if they are to be a corporation, who gave them the right to take or give rights to the living man or woman? Well, depends on what kind of rights you're talking about. But natural rights, no. Come from the laws of nature, no. But, the right to hold the office of governor, well, that can be taken from you, because that's not a natural right. But we, the people, have that power, and those are supposed to be our public servants. Plain and simple. They're supposed to serve the people, of the people, by the people, for the people. But a lot of people are not aware that they have fundamentally altered our form of government. And I hate to burst a lot of people's bubbles out there, but even this Constitution we're reading from here is a fraud. In reading from the documents illustrated with the formation of the Union of the American States, that union, that confederacy, that League of Friendship, a Confederate Republic, is what our founders created, a Confederate Republic. Um, man, I lost my train of thought on that. Oh yeah, the Constitution. I found in their secret debates, and they usurped their powers that were delegated to the delegates in the Constitutional Convention to begin with. And not only that, I found the 1787 Constitution as well. It's in there. So that documents illustrated the formation of the Union of the American States is actually a really good read. But see, they fundamentally altered our form of government, and the first so-called Constitution there of 1789, which some will say 1787, it's not, 1789. Okay? Was the first bankruptcy. That might be a shocker to a lot of people, but that's the truth. And Thomas Jefferson was pissed when they did what they did and they came back with that Constitution. And he found out that this was all frickin' bankruptcy. Just a little tidbit of history for you. Okay? Yep, rights cannot be taken, but privileges can. Well, rights can be taken. Following due process of law, either under the consent of a jury or by the law of the land. We can absolutely deprive fundamental rights, just not through legislation. As long as there's standing in a cause of action, you most certainly can deprive a man of his liberty. You most certainly can lock him up. If he commits murder, you could take his life. Okay, murder is supposed to be a capital offense, capital crime. Same thing with rape and kidnapping. And per the common law, so is abortion. Considered a felony. But I know that we've progressed from that. So hopefully that clears up a few things on whether Congress has subject matter jurisdiction or not, and the states do not over migration. They most certainly can prohibit it. They most certainly can regulate it. You know, and this is the thing is, we're not supposed to just be wide open borders and anybody can come in here. There's a lot of nation state countries out there that will just literally shoot you on the spot as soon as you trespass. So you might want to go read some Law of Nations and, you know, more real law of nations, and understand that fundamental principle about defending your nation. So, there is that. Now, let's get into Blackstone's Commentaries on the Law of England, where we're going to pick up where we left off. I'm going to back up to this beginning of this paragraph here after 149. And this is still talking about those auxiliary rights. Okay? And this started getting into, and the reason why I stopped there, because this is going to be some good stuff here, folks, about the assembly. You know, previous above this was talking about the right of petition to the assembly, to the legislative branch. So this is picking up from where we left off last week. Hence it indisputably appears that parliaments or general councils are coeval with the kingdom itself. How those parliaments were constituted and composed is another question, which has been a matter of great dispute among our learned antiquaries, and particularly whether the commons were summoned at all, or if summoned, at what period they began to form a distinct assembly. Well, here in America, it was the Virginia Ordinance of 1621. And they created that General Assembly, and the General Court But even clear back to the Magna Carta, 1215, the grand jury. And actually, just a little bit before that was the Aziz of Clarendon, which, that's what this is talking about right here. Says it had never been yet ascertained by the General Assize or Assembly, but was left to the custom of particular counties. Let's see. But it is not my intention here to enter into controversies of this sort. I hold it sufficient that in generally agreed that in the main, the Constitution of Parliament, as it now stands, was marked out so long ago as the 17th year of King John A.D. 1215, in the great charter granted by that prince, wherein he promises to summon all archbishops, bishops, abbots, earls, and greater barons personally, and all other tenants in chief under the crown by the sheriff and bailiffs, to meet at a certain place with 40 days' notice to assess aids and scutages when necessary. And this Constitution has subsisted, in fact, at least from the year 1266, with Henry III, there being still extant writs of that date to summon knights, citizens, and burgesses to Parliament. I proceed therefore to inquire wherein consists this Constitution of Parliament, as it now stands and has stood for the space of at least 500 years. Okay, now again, this is clear back when Blackstone wrote this. So 500 years prior to that, because this is in early 1700 when he wrote this. So, So for 500 years, this right's been developed before he even wrote this. And in the prosecution of this inquiry, inquiry, that's one of them words that go with the common law grand juries. They do their grand inquest or an inquiry, and they have the right to do their own investigations. I shall consider, first, the manner and time of its assembling. Secondly, its constituent parts. Thirdly, the laws and customs relating to Parliament, considered as one aggregate body. Fourthly and fifthly, the laws and customs relating to each house. See, it's a house, the whole thing. But there's two parts to the house. What we call a Senate and House of Representatives. That's still the whole house. Okay. Separately and distinctly taken. Sixthly, the methods of proceeding and making statutes in both houses. And lastly, the manner of the Parliament's adjournment, prorogation, and dissolution, their prerogative. Whoops. What just happened? Oh, I decided to refresh and skip the page on me. So this is going to be number 1, the start of 150. As to the manner and time of assembling, the Parliament is regularly to be summoned by the King's writ or letter issued out of Chancery by advice of the Privy Council at least 40 days before it begins to sit. Number 2. Oh, wait. Dang it. What are you doing? Oh, okay. But why is it doing that? Being flaky on me here. That's weird because it just says, oh, it. Okay, it is a branch of the royal prerogative that no parliament can be convened by its own authority or by the authority of any except the king alone. And this prerogative is founded upon very good reason. for supposing it had a right to meet spontaneously without being called together, it is impossible to conceive that all the members in each of the houses would agree unanimously upon the proper time and place of meeting. So this is part of the reason why it's written in the Constitution that the day that they are supposed to assemble for your legislative session and Congress. So that's probably why. We didn't have to argue about when they were going to assemble. It's set in stone by the people. That's when you're going to assemble. We, the people, tell you when you're going to assemble. And if half of the members met and half absented themselves, who shall determine which is really the legislative body, the part assembled, or that which stays away? That's right. It is therefore necessary that the Parliament should be called together at a determinate time and place, and highly becoming its dignity and independence, that it should be called together by none but one of its own constituent parts, and of the three constituent parts, this office can only appertain to the king, as he is a single person, whose will may be uniform and steady, the first person in the nation being superior to both houses in dignity, and the only branch of the legislature that has a separate existence, and is capable of performing any act at a time when no parliament is in being. Nor is it an exception to this rule that by some modern statutes on the demise of the king or queen, if there be then no parliament in being, the last parliament revives, and is to sit again for 6 months, unless dissolved by the successor. For this revived parliament must have been originally summoned by the crown. So, in today's timing, we already have it set, again, in the constitutions of when they're supposed to meet. When the legislative session is called into session every year. Actually, not true. Not every state does every year. Some states actually do every other year. But I want to remind people that they have what's called standing committees. Those committees, technically speaking, are there year-round, all the time. They may not meet every day, but most of the time, like once a week, these standing committees are there. It is true that by a statute in 16 Charles, blah, 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 it was enacted that if the king neglected to call a parliament for 3 years, the peers might assemble and issue out writs for choosing one. And in case of neglect of the peers, the constituents might meet and elect one themselves. But this, if ever put in practice, would have been liable to all the inconveniences I've just now stated, and the act itself was esteemed so highly detrimental and injurious to the royal prerogative that it was repealed by statute, from thence therefore no precedent can be drawn. So yeah, they don't want Parliament taking power from the king, but they did. And that's what the Magna Carta started to do, was stripping the king of all these powers that he thought he had. Which, under monarchy and under Catholicism, that's the way they want it. They want everybody slaves, subjects, and subject to the king, and whatever the king says goes. You have privileges, you don't have rights. That's why Roman civil law, when you say civil rights, they're not rights, they're privileges. And if they're privileges, they can be taken away at any time. Rights are unalienable. You cannot take them away. You can't place a lien upon them because property is an aggregate of guaranteed rights. The guaranteed rights come from the laws of nature, from God. But for those that don't believe in God out there, we still have the laws of nature. These are natural rights. Okay? It is also true that the Convention, Parliament, which restored King Charles II, met above a month before his return, the Lords by their own authority, and the Commons in pursuance of writs issued in the name of the keepers of the liberty of England, by authority of Parliament, and that the said Parliament sat till the 29th of December, full 7 months after the Restoration, and enacted many laws, several of which are still in force. But this was for the necessity of the thing, which supersedes all law. For if they had not so met, it was morally impossible that the kingdom should have settled in peace. Now, again, this is still under the monarchy. And the way the Saxons, Anglo-Saxons, but more towards the Saxon side, which was the Christian Protestants, really wanted the fundamental principles that man is to be free, equal, independent of all government. That no matter what government says, it doesn't apply, because that comes in conflict with being free, freedom of choice, liberty of conscience, right of self-determination. Okay? And the first thing done after the king's return was to pass an act declaring this to be a good parliament, notwithstanding the defect of the king's writs. So that as the royal prerogative was chiefly wounded by their so meeting, and as the king himself, who alone had a right to object, consented to waive the objection. This cannot be drawn into an example in the prejudice of the rights of the crown, because he gave his consent. Right? I approve of your parliament that you've assembled. These are lawfully assembled people, blah, 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 blah. Okay? And when he approves, then whatever they make there, essentially, is what the king has to deal with. So this is kind of, in part in history why we need to learn this stuff, because we have to understand how we had to, the people in this particular time period, had to strip the king of these powers. And even then, which we're going to get into the English Bill of Rights here coming up, is that even in 1688, 1689, they'd had enough. They'd had enough in 1215. They'd had enough in 600 AD. They had enough in 400 AD. They had enough in 400 BC. How many times have I said this, folks? This stuff's been happening over and over and over and over again, all throughout history. Besides, we should also remember that it was at that time a great doubt among the lawyers whether even this healing act made it a good parliament, and held by very many in the negative, though it seems to have been too nice a scruple. And yet, out of abundant caution, it was thought necessary to confirm its acts in the next parliament by statute 13, blah, blah, blah. So, they actually had to confirm this stuff by the next parliament. So, the one parliament would assemble, make the laws, and then the next parliament would come in and confirm it. We have that kind of a oversight thingy going on in our Republican form of government. It's called gubernatorial veto power. See, this is one of the parts of the executive branch, acting as either governor or president, has the power to provide oversight of what the legislature makes. Not only that, we the people have the right to remonstrate against this stuff. And then we're supposed to have the power in our through our common law juries and common law trials, trial by a jury, to judge the law and the facts. That was one of the ways that we, the people, were able to abolish legislation. Now, do you understand why they wanted to take that power from us? Because they wanted to enslave us all and turn us back into good little subjects, good little taxpayer slaves. Go to work, pay your taxes, have your fun, and you'll be fine. But don't you dare break one of our laws, because, well, we say so. It's all code. It's all bills of attainder and bills of pains and penalties. That's the code, Roman civil law. So, it is likewise true that at the time of the Revolution, AD, there was a revolution in AD 1688? Yes, there was. The Lords and the Commons, by their own authority and upon the summons of the Prince of Orange, afterwards King William, met in a convention, and therein disposed of the crown and kingdom. But it must be remembered that this assembling was upon a like principle of necessity as at the Restoration, that is, upon a full conviction that King James II had abdicated the government, and that the throne was thereby vacant, which supposition of the individual members was confirmed by their concurrent resolution when they actually came together. And in such a case as the palpable vacancy of a throne, it follows ex necessita rei that the form of the royal writs must be laid aside, otherwise no parliament can ever meet again. So, out of necessity, that's how that happened. How William and Mary. That's how this all happened here. There was a Revolutionary War in 1688. And the English Bill of Rights of 1688 or 1689 is what that came out of that. So there's a point in time there where, hey, had enough. We're doing this again. Shutting her all down and doing like a factory reset, kind of. Back to the law and putting the king in check. Now, I'm wondering if they didn't kill the king, and that's how that happened to be vacant. But I'm not sure. The vacancy of the throne was precedent to the meeting without any royal summons, not a consequence of it. They did not assemble without writ and then make the throne vacant. But the throne being previously vacant by the king's abdication, I have to look that word up. Maybe he just gave up. I don't know. They assembled without writ, as they must do if they assembled at all. Had the throne been full, their meeting would not have been regular, but as it was really empty, such meeting became an absolutely necessary. And accordingly, it is declared by statute, 1 William and Mary, this is the English Bill of Rights, that this convention was really the two houses of Parliament, notwithstanding the want of writs, or rather defects of the form, so that notwithstanding these two capital exceptions, which were justifiable only on a principle of necessity, and each of which are by way induced a revolution in the government, the rule laid down is in general certain that the king only can convoke a parliament. Well, do you see some defects in this? And then again, it's still under the monarchy, and that's just their form of government. Okay, somebody's saying it means it has stepped down and passed the crown to the next in line. Well, clearly there was nobody else in line. That's why Parliament had to assemble and make prince. Maybe that's just how that works. I don't know. I don't know, George. Over here on Telegram, is that why Socrates was put to death? He started questioning everything. Yeah, I don't know. It could be a reason. A lot of people don't like questioning their authority. You're just supposed to bow down to them. Judge Dredd, I am the law. Which enacts that a statute of Charles II had done before, that a new parliament shall be called within 3 years after the determination of the former. So, oh, wait. Did I scroll down past something? Oh, okay. Let's go back up here. And this by the ancient statutes of the realm, he is bound to do every year or oftener if need be. Not that he is, or ever was, obliged by these statutes to call a new parliament every year, but only to permit a parliament to sit annually for the redress of grievances. So, this is in practice now what the legislature is supposed to be for redress of grievances. That's that right of petition for the redress of grievances. And dispatch of business, if need be. These last words are so loose and vague that such of our monarchs as were inclined to govern without parliaments neglected the convoking them sometimes for a very considerable period, assembling basically, under pretense that there was no need of them. Well, I'm the king, we don't need any of that. But to remedy this by the statute of 16 Charles II, blah, 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 it is enacted that the sitting and holding of parliaments shall not be intermitted above 3 years at the most. And by the statute of Statutes 1, William and Mary, section 2 there, it is declared to be one of the rights of the people that for redress of all grievances and for the amending, strengthening, preserving the laws, see, would that be that alter, reform, or abolish? And the redress of grievances? Parliaments ought to be held frequently. That's even in some of our 1776 era constitutions, says that the legislature shall assemble frequently. And that we need to have a frequent reoccurrence to fundamental principles, and that so that we could petition the legislature for the redress of grievances. So, then in 6W, William and Mary, chapter 2 there, which enacts, as the statute of Charles II had done before, that a new parliament shall be called within 3 years after the determination of the former. Well, that's not frequently. Well, there's some voting on that. Yeah, we're doing good. All right, section 2 now. This is going to be that, those, I don't know how many different parts there was. There's 7 or something like that. The constituent parts of a parliament are the next objects of our inquiry, and these are the King's Majesty, sitting there in his royal political capacity, and the 3 estates of the realm, the Lords Spiritual, the Lords Temporal, who sit together with the King in one house, and the Commons, who sit by themselves in another. So the Commons sit by themselves. You bunch of commoners over there, you're not part of the being a lord, part of the church, and being in the spiritual realm or the temporal chancery. And the king and these 3 estates together form the great corporation or body politic of the kingdom. Now, this is where we get into our form of government, is where the people became the sovereign body politic. All power is inherent in the people, all political power. And Law of Nations, was it Book 1, Chapter 1, Section 3. Without which there can be no beginning of a parliament. And he also has alone the power of dissolving them. So that's one of those things that's in the Declaration of Independence, in the English Bill of Rights, is that the king was dissolving our legislative assemblies. And then putting in his own people. It is highly necessary for the preserving the balance of the Constitution that the executive power should be a branch, though not the whole, of the legislative. See, remember, this was all combined into one, legislative, executive, and even the judicial. It was all just kind of all one thing, even though through time it kind of got a little separated between the king as the judge and his, whoever he has over there for that. And what we would call the legislative executive. Let's see. The total union of them, we have seen, would be productive of tyranny. Imagine that. The total disjunction of them for the present would in the end produce the same effects by causing that union against which it seems to provide. The legislative would soon become tyrannical by making continual encroachments and gradually assuming to itself the rights of the executive power. Thus, the long parliament of Charles I, while it enacted in a constitutional manner, with the royal concurrence, redressed many heavy grievances and established many salutary laws. But when the two houses assumed the power of legislation, in exclusion of the royal authority, they soon after assumed likewise the reins of administration. And in consequence of these united powers, overturned both church and state. See, this is what was going on there. That in the Lord spiritual and Lord temporal. Okay? That's why these judges wear black robes now. We're back under that crap. To hinder administration, and in consequence of these united powers overturned both church and state, and established a worse oppression than any they pretended to remedy. To hinder, therefore, any such encroachments, the king is himself a part of the parliament. And as this is the reason of his being so very properly, therefore the share of legislation, which the Constitution has placed in the crown, consists in the power of rejecting rather than resolving. So that's what we have today. The governor and the president has the power to reject. But he has to give his rejections and can be sent back. And with a 3/4 majority, it still can be passed. In my mind, without the objections. Less the objections. This being sufficient to answer the end proposed. For we may apply to the royal negative, in this instance, what Serco observes of the negative of the Roman tribunes, that the crown has not any power of doing wrong. Oh, we see a problem with that Roman civil law stuff. Well, the king can never do any wrong, but merely of preventing wrong from being done. Right. Does anybody else see a problem with this kind of form of government? And these people having a hierarchy here in our society where we have rulers. Does anybody have a problem with that? I mean, I do. The crown cannot begin of itself any alterations in the present established law, but it may approve or disapprove of the alterations suggested and consented to by the two houses. The legislative therefore cannot abridge the executive power of any rights which it now has by law without its own consent, since the law must perpetually stand as it now does unless all the powers will agree to alter it. And herein indeed consists the true excellence of the English government, that all the parts of it form a mutual check upon each other. Not like our three branches of government, three distinct branches, where this was just essentially two. And see, many people don't get that about our form of government too, is that the three distinct branches, they all provide oversight of each other. But we've all been taught, well, everything goes to the judicial branch. But what happens when you have a problem with the judicial branch? You have a grievance, you go to the legislative branch. If you got a problem with the executive, you go to the legislative branch. That's a grievance. You got a problem here. The legislature is the one that essentially creates certain things. But if we, the people, create the Constitution, and then we use, the power of the legislature But see, even now, if we get back into the common law, or true republican form of government, and we go to the common law side of our republic, where the people have the right of inquiry to assemble 25 men as a grand jury to do an investigation and indict a public servant, yeah, that's what we need to do. We need to reassemble government de jure. We need to take back our common law power. We need to reassemble the common law side of our republic, where the people have all the power. We have the right to alter, reform, or abolish anything and any time we deem it necessary. That's supposed to be done by us, not by them. We're supposed to be providing oversight of all three branches, because we, the people, created it, and that makes us the sovereign. The people are the sovereign body politic. They're only vested with certain powers. Okay? But it doesn't matter even if we do vest them with certain powers. We still have the right to provide oversight. That is the best place for the power to be, is in the people's hands. That way we don't get turned back into a monarchy. Go back to that Article 4, Section 4, that internal insurrection, that domestic violence. That's what that's supposed to help prevent. The people are supposed to keep that at bay. But sometimes, and that's why they wrote that in there, because they understood everything that they just went through here. Same crap. Over and over again. If you don't think that these people back then knew all this stuff, just as I'm going over it with you right now, they knew it. Now I know it because I've studied it. I've learned it. I've learned the history of this crap. I get that it's all Roman civil law, the code, that's been a problem throughout history. And this usurpation of power, bills of attainder, and creating these officers here, which is even in the Magna Carta, for those that were on Friday night, over there on just the one Telegram channel, the KLC American Patriots, MC, that's the master channel, going over Lysander Spooner's essay on trial by jury, he's exposing how they've altered, in the translation, going from Latin to Greek to English, how they, even Lord Cook and, some other people there that mistranslated purposely, but nonetheless that they're not supposed to send, the sheriff or any armed men to harass us in 1215. 700 years ago. So, again, if that was a limitation on the king in 1215, 700 years ago, then it's most certainly a limitation on our public servants here in America today. There's no way that we would regress back to this form of government that's so out of whack, balance of power, with the king's prerogative, that he can just do whatever he wants to do, and because the king says so. No, I don't think so. Even in a set of men. No. We, the people, need to lay down the law. We declare it. And that's the law. And then we institute government to secure that rights, law, from infringement. And that's the whole intent of creating government to begin with, is, right? That, I always go back to that intent. What is the intent of instituting government? That to secure these rights. So when our supposed government is no longer following the intent of creation, we have an indubitable right, an indefeasible right. And it's not just a right, it's a duty to throw off such despotism and institute new guards for our future security and safety. Now, we're not supposed to overthrow the government for light and transient causes. Now, for the most part, aside from a little bit of the corruption there in creating this Constitution that we go by today and throughout, that our founders, in essence, created one hell of a form of government, a Confederate Republic, which on the National Assembly call here, 2 weeks ago now, I found that in Montesquieu's Spirit of Laws book here, where it talks about Confederate Republic and how a monarchy is about, they're just all about war. So we don't want a monarchy form of government, man. We want to go back to a Confederate Republic where we all defend one another and we come to each other's aid in defending the nation called America, while still being independent sovereign nation states. So it's like one big family, but it's all on one chunk of land, but we all have our own houses. And when you see one house starting to catch on fire, everybody else comes over there to help put that house out. Or if the house gets burned down, everybody comes over and helps rebuild the house. And then we go after the bastards that frickin' burn it down to begin with. Okay? Yep, I've heard those slap suits. Strategic lawsuit against public participation. Threats against the right to petition government often take form of slap suits by by tyrants. Angel over here on Telegram. It's called KLC American Patriots MC. I don't know if. Let me see if I can pull that over here. I don't think I can. Well, maybe. Wait. Yeah. Yep. I can. I can get to it. I wish I could post it over here somehow and it would go out to all of them, but that's weird. Oh, okay, I guess there are some people still on Facebook. Okay. I just put that link in the Telegram there for those on Telegram. And that's Friday nights at 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. Central, 9 p.m. Eastern. And that's strictly just kind of government de jure and our assembly stuff. And why I'm going over that right to trial by jury is because we need to learn how that works. That's how we function on the common law side and how we're supposed to be indicting public servants. Because that's the process that's due to them. Right? Got to have an investigation. And it has to be an independent. So, that's where we've made it through history on this. And it's best to be in the people's hands. Least danger of maladministration and tyranny, corruption, despotism. You know, you got that maladministration. You got misfeasance, malfeasance, misprison of treason, and that whole petitioning and being met with repeated injuries after you petition. Man, that's kibosh on that. But I can tell you right now, there's not many people who are exercising their right to petition the legislature for the redress of grievances. because most people don't even know that right, how that right works. But been out here trying to teach that since, 2017? Okay, in the legislature, we're at section 155 now. In the legislature, the people are a check upon the nobility. So even in the monarch here, what are they saying? And what's the status? The people. By the mutual privilege of rejecting what the other has resolved. So, technically speaking, we should really be putting them all to a vote, right? Every single, well, I guess we should, doesn't necessarily mean we should put everything to a vote after the legislature passes and the executive approves it. But there's no reason why we can't. But again, once we reassemble and we get back to of the people, by the people, for the people, and we start, you got to be one of the people, and you have to qualify as an elector to be elected as governor. You got to be one of the people. None of this bought off, paid off jackwagons over there. Yeah, I don't think we want that no more, right? I'm not game for that. But what I am game for is the people coming back together, uniting. Because united, we will prevail. Divided, we will fail. We'll fall. So we need to unite, folks. We need to come together. The people need to come together, and you declare your status as one of the people. People talk about changing your status out there. You want to become one of the people. That national thing, that doesn't exist. That's all shmew made up by the bar in 1878. That's when the origin of that word came about, was a national, and it only exists in the United States Code, which is Roman civil law, all orchestrated and perpetrated by the bar. Again. Oddly enough, that's when the American Bar Association was created in 1878. Huh. Kind of weird, huh? While the king is a check upon both, which preserves the executive power from encroachments, and this very executive power is again checked and kept within due bounds by the two houses. Through the privilege they have of inquiring into, impeaching, and punishing the conduct, not indeed of the king, which would destroy his constitutional independence, but which is a more beneficial to the public, of his evil and pernicious counselors. Would that be them esquires? Them Crown Temple Bar counselors? Thus every branch of our civil polity supports and is supported, regulates and is regulated by the rest. Now, again, this is 1689, so this is essentially getting into that era there of where things really started changing. But I can tell you right now, the real first major change of transferring that power from all of these councils and this pernicious projects and all that stuff was 1621 with the Ordinance of Virginia, when they set up the General Assembly and the General Court that's supposed to be done by the representatives at that particular point in time. But that was the people starting to assemble. And this was outside of who the king thought should be in there. But see, when the people were starting to be happy, well, we can't have that. Got to have war. Because that's how a monarchy works. Okay? So they're all about war. They're not about peace. They don't want peace. They want people to live in peace. They already got to come in there and poke the bear all the time. They're always frickin' poking the bear. And then, in our instance, now we've gotten to the point where most of our civilization population of the people, men and women, kids these days, our children, sons and daughters, have been dumbed down, brainwashed, indoctrinated to not know anything. I was going to say to believe, but they don't believe anything. I don't know. Can't even have a conversation with some of these people that are, I don't know, even some that are in their 40s. It's I don't know. It's hard for me, anyways. I don't know about the rest of you, but trying to have conversation about real law with some of these people, I don't know. It's hard. But I'm definitely trying to get better at it. Right, James? They will vote harder. I agree. I agree with that, Mark. Out here on YouTube, that people are just trying to keep gas in their cars and food in their bellies right now. No, I get that, and we're in for a pretty good surprise. It's coming. Whether the mass of population is ready or not. But, I've been covering this stuff since September of 2017 when these executive orders and stuff came out. Executive Order 13818. Then extended again till December 20th, 2024. So, until that executive order is taken care of, that state of emergency, enemy attack, which is again blocking the property of those involved in serious human rights abuse and corruption, that's what makes Trump the wartime president. I know some people out there are talking about some other executive order that's 139, which would be after. No. Nope. This is under two federal directives, a continuity of government, and the executive order 13818 is a worldwide executive order. That's the executive order that is the primary executive order for everything that's going on. Okay? That's the one that blocks the property of those involved in serious human rights abuse and corruption. It was designed to take down bad governmental regimes, institute new governments, hold elections, and put, new guards in there and train their military. Train their militia. Right, Tiger? Nothing can stop what's coming. This has already been set in stone. It's been on the move since essentially 2016, possibly even as far back as 2015. Into action for sure after Executive Order 13818. That was the kickoff. All right, so back to this over here. Checking on both that preserves the executive for encroachments. As very executive powers again checked and kept within the bounds of two houses through privilege of inquiring into it. Impeachment, punishing the conduct, which would destroy his constitutional independence, but which is more beneficial to the public, of his evil and pernicious counselors. Right. Every branch of civil policy supports and supported, regulates, and the rest. Naturally drawn into two directions of opposite interest, and the prerogative in another still different from them both, they mutually keep each other from exceeding their proper limits, while the whole is prevented from separation and artificially connected together by the mixed nature of the crown, which is a part of the legislature and the sole executive magistrate. So, like three distinct powers in the mechanics, they jointly impel the machine of government in a direction different from what either acting by itself would have done. Gee, it's amazing that they actually refer to mechanics and a machine of government. I wonder why I'm so good at this. That extremely high mechanical aptitude. Diagnostics. But you have to know how it's supposed to be first to know what's wrong with it. And not what they tell us the way it's supposed to be, but diving through history and finding the issues, the problems, this despotism, this tyranny. What is it? Well, you got to read, you got to study, and you got to find out. And then once you learn, you're like, whoa, wait a minute. I recognize that as tyranny. That happened back in, 1215, 1688. That happened in, 600 AD. With the Lombard invasion. Once you learn the telltale signs of what tyranny is, what a tyrant is, what despotism is, it sticks out like a frickin' sore thumb, let me tell you. That TV show, I see dead people, I see tyranny all the time. Everywhere I walk, everywhere I go. We are surrounded by tyranny. Yeah, right, Karen? Out here on YouTube, government needs a tune-up, or perhaps an overhaul. It does. It needs a complete overhaul because the form of government and the way they've been acting, essentially, even since 1789, is not right. So, you look at 1689, it didn't take but less than 100 years to get corrupt again. Now, one of the things I have heard out there is that we're supposed to have these little kind of civil wars every 20 years. Absolutely, Danny, out there on Facebook. Says, thank you, sir, for education. I saw this all back in the mid-70s when I was a preteen. You and me both. I was born in 71, so kind of know what you're talking about. Now, you might be a little bit older than me, but my first experience of corruption was in 1985, when I was the child that was kidnapped by CPS of state of Washington, thrown into foster care. Ripped my whole family apart. Separated us all. Yeah. And then lied to me to my face and tell me, if your mother loved you, you'd be back home by now. Yeah. Pow, right in the kisser. I let that social worker have it. I wasn't having any of that, talking bad about my mom, how my mom supposedly doesn't love me. Well, why are you keeping me from her then? Right. I know. I know firsthand. I know how corrupt they are. And if you think they've changed any since even 1985, no, it's the same old crap. Although maybe things have gotten a little bit worse because now they make up things like, oh, well, you got laundry on the floor, or you got dishes on the counters or in the sink, and oh, your sink's it's dirty, and now that's none of your damn business how people live. Where's the willful deprivation of food or clothing? And that's willful, malice, criminal in nature. No, they use their star chambers, back to these star chambers, and most of the time they don't allow anybody in there, except for the parties. Sometimes they'll allow certain family members to be in there, but 90% of the time, I should say 99% of the time, they will not allow anybody else in there in these, and that's what makes them star chambers. All courts are supposed to be open. All courts are supposed to be open. Back to the Spanish Inquisition and star chambers. Right? Yeah, thank you, brother Danny out there on Facebook. Appreciate it. Yeah, so I'm very well aware of corruption. Lived it pretty much all throughout my life, and I've just had enough. And like I've said before, sitting in the jail cell in 1995, I made a vow to God that I'd start studying law so that I wouldn't get screwed like that again. They lied, fabricated evidence. And even after I'd proved that the cop didn't have probable cause to pull me over on the no proof of insurance ticket, case should have been dismissed. The no proof of insurance case got dismissed, but that's that stupid, what do you call it? Infractions, bills of pains and penalties, bills of attainder. But I never thought that I'd be sitting here dedicating my life to educating my fellow man. Aside from studying and researching to the point that I have, and continue to deep dive and find all sorts of goodies, putting this 10,000 piece puzzle together. So, never thought that I'd be right here, right now, doing this. Maybe helping people with their own personal cases, maybe to that point, but not dedicating my life as much as I've had, literally. Especially over the last 6-7 years, has pretty much been every day reading some sort of law, something, somewhere. And those of you who've been following me long enough, without much of a vacation or taking time off. Yep. We were born for such a time as this. That's why everybody else is here. We're all in this together, and I greatly appreciate everybody being here right now and who watches these later, trying to learn, trying to get And this is the reason why I'm going back to Blackstone's. Well, Supreme Court cites it as a source of law and authority, which cites laws of nature and the those three absolute rights from nature: the right of personal security, the right of personal liberty, which consists in the power of locomotion. It's not the right to travel, folks. So for those of you out there that like to fight the whole driver's license here in the traffic stuff, first, traffic literally means commerce, trade. So there's your lack of subject matter jurisdiction. They say motor vehicle. No, subject matter jurisdiction is commerce. And commerce was granted to Congress, Article 1, Section 8, Clause 3. So therefore, admiralty jurisdiction being extended onto the land again, so your territorial jurisdiction, lack of personal, lack of subject, and lack of territorial, if you're not acting in commerce. And then that legislation has to come from Congress, and it has to be uniform throughout the whole union, because that power is delegated to Congress, which means the states don't have any legislative authority over the subject of commerce. There is no subject matter jurisdiction over motor vehicle. It's all a scheme, scam, and a fraud. Yep, I agree with that. All of us that are eldest grandson and or the firstborn son of our family have a duty to stand up and take back our authority and God given rights to protect and set our own house in order. Yeah, technically speaking, every able bodied male between the age of 17 to 64 is automatically duty bound to be in the unorganized portion of the militia to defend our republic, our form of government, to defend life, liberty, and property or pursuit of happiness. We're supposed to be doing that, and that's why they're pushing that bill right now. They don't want us to stand up because they see what's coming because they're probably in part behind it. But I'm telling you, folks, there's coming a time here where we may actually have to take up arms and defend ourselves. This foreign invasion, again, it's an invasion, not a migration. They're not coming here lawfully. You know, one man, one woman, or a family might migrate here, but they would apply to come here because Congress has that authority to regulate that. Immigration, naturalization. But other than that, this is an invasion. There are thousands of men coming across that border, some women, every day. Thank you, Tiger. Thank you, Rita. I know, right, Danny? Feels lonely, but God has never let me down. You know what? I'm right there with you. I gave this stuff up to God. Everything in my life has been given up to God, and whatever God sees fit to provide for me, that's it. That's, you know, I live well below the poverty level, and crap, most of my life I've lived below the poverty level, so I'm pretty used to it and pretty comfortable. I have my basic needs and necessities met, you know, food, clothing, shelter. I'm good. What does God tells us that our treasures or whatever will be in heaven, right? So, on one aspect, I can't wait to get there. On another aspect, I feel like I got something to take care of down here first, and I think that's where you're at there too, Danny, and some other people out here. So, all right, good night, Tiger. We'll see you next time. See you Friday night or Thursday. Probably won't see me Thursday, but Friday you can. Been a long week and it's only Monday. Yeah. Oh crap. Where'd the time go? Sitting here chitter chatting. Wanted to get through this. Well, anyways, we'll call it a night for right here. At 1:55, I'm going to put that in here, which will be part 9. Because we're getting into the powers that this political power, folks, and it's done through the legislature. But like I've said before and was talking about on Friday night, that we're supposed to have this power on the common law side. This is what's missing from our republic. Is the common law side of our republic, where the people have all the power. So that's over here on the National Assembly, where I'm trying to get people to go. Okay. And I put the link over there, but I'm going to show it right here, right now. You go to forums, National Assembly forums. Uh-oh. What's it doing? Okay, and then you're going to want to scroll down here to where it talks about the 50 nation states. Okay, this is where your forum is, your basically your chat and all that good stuff. Okay, this is where you're going to want to go. If you're new and are not connected, this is how you get connected with your state, at least an attempt. Okay, and I posted here in Idaho. I put it in there. I put it in there when I first got in here. I went into the introductions. And then I just posted both in introduction and the general chat. That same thing I put out there before, trying to get people to, especially from Idaho, but everybody. But I've got, links to the playlist for Red Beckman videos. I've had to go and find them because the ones that were linked on here, and I'm trying to get with Destry on that to see if he can relink them, and I may actually figure out a way to download them so I actually have them. And I was meaning well over a year ago to kind of redo those Red Beckman videos with more updated information, law stuff that I have discovered that's different from what Red taught. And, yeah. Scrimshaw, good to see you. And Leslie, haha. Right? Wealth is not money. Thank you, Diesel D's. Yeah. So, just trying to, get people to come over here and start coming together. And from there, that's how you can kind of get in there. And then, possibly get on the Thursday night call, which is right here, conference call info, 6 p.m. Pacific, 9 p.m. Eastern. The first part is the assembly business. The second part's the general discussion, education, Q&A. Okay, here's some videos on how to install it and use it on your phones. This one's for desktops, laptops, and tablets. Okay, to join the online meeting right here. I highly recommend you download and install the free conference call app. Whatever it's on your phone, tablets, whatever, desktop, use the app. It's so much easier. But if you're still one of those ones that do not, don't do smartphones, which I have a friend of ours here, part of the team at the office there. He doesn't do a smartphone. He's got a flip phone. He hates them. So you can dial in, and it's *6 to unmute and mute. Thank you, Kat G on YouTube. And James, yep, thank you too. And Jax, there you are, Jax. I was wondering where you was hiding out. Thanks for sending that to me over on X. I don't know if you caught that, but I put that bill up here warning people. But, yeah. So Thursday nights for the free conference call on the National Assembly here. Okay? And again, the website's national-assembly.net. And you can start right here. Resources, current situation, where are we the people? Public notices, 1638 fundamental order, assembly supporting videos. Now this is where some of those videos no longer working in there. The other one is important censored videos and the 10 steps to an assembly. That's one of the links that I put in the post that I made to start there, and that's where we need to start. We got to start reassembling, folks. Yeah, so yeah, thanks for the find on that, Jax. All right, and then of course my website, kirkslawcorner.com. Made a little updates to the website. put in a mission, what the mission statement is, which is educating the people on what our rights are, where they come from, and how to effectively claim, exercise, and defend them following due process of law. Due process of law is the process that we, the people, have as a matter of right. Now, this is in there before. Now, I've also worked on the email list. So, I believe I have access. I haven't sent anything out yet. And I want to let the 1,700 people that have did this here and gave me your email. I didn't know how to do it. I had a meeting with Dave and Miles on, was it Friday? Or was that Saturday? Saturday. Was it Sunday? Yeah, I think it was Sunday. See, days are blurring together. I've been on a lot of phone calls and meetings lately, let me tell you, folks. But anyways, I think we got that kind of ironed out. So those of you that have dumped your email in here, subscribed essentially, I want to thank you. And again, I will never sell that list to anybody. I will safeguard that information the best that I can. I will not give out anybody's email address. I will not spam you. If I send out an email, it'll be for a purpose. I'm not going to just randomly throw crap together and send you a bunch of spam. That's what I call spam. Even though some of it might be news and all that stuff, if it's something worthwhile, yeah, sure, I might do that. And then we're actually talking about possibly doing a blog on here. So that may be coming soon. I might start blogging on my own website. And then there's a back end here, which there's no way to see it for those on Patreon. So if you want to get in on Wednesday Night Workshop now, I'm going to be uploading those videos to a private place, and everybody that's in Patreon on Wednesday Night Workshop will have access to the back end of my website. So it's essentially been completed. It's kind of got to get organized on it, clean it up. But yeah, that's essentially created. Yes, Jax, that's who it was. Yep, I met with Dave. I asked Dave, finally contacted him, and he said sure. So he helped, and so shout out to both Dave and Miles. And I told Miles, I asked him about this thing, the Davina website, and he's like, oh yeah, that. And I said, well, put your name on there. So Miles does websites. So if you want to hire him to do something for you, you just click on that right there. You can get right to him. Okay. So greatly appreciate both you brothers, both Dave and Miles. Thank you. Other than that, if you'd like to help support through the old-fashioned way, through the mail, you can support through Patreon. Tier 1, Tier 2 is one's $5, one's $10 a month. Basically, it's a cup of coffee. These days, some coffee's almost like $7. But anyways, you can subscribe through there, and whatever you want, any amount if you want, to help. That's the digital side. Other than that, Wednesday Night Workshop is Tier 3, and if you want one-on-one time with me, that's Tier 4. Otherwise, can you send stuff over to the office there through the snail mail? Any of them postal money orders, regular money orders, cash wrapped aluminum foil, gold, silver coinage, or any law books? Again, I don't have any on my wish list as of right now. Well, maybe Blackstone's Commentaries on the Law of England. Those, I'm pretty sure those would be pretty difficult to find, and more specifically, older ones. None of these newer, revised garbage ones. But hey, never know. Somebody might have some laying around. Somebody might find them out there, Amazon or a bookstore. Other than that, send that stuff over there to the office, 6477 West Fairview Avenue, Suite G, as in golf. Moved upstairs in the big office and the classroom. Boise, Idaho 83704. I want to thank all those that have given support in the past and present time, and those in the future that may decide to help support my efforts here. Like I said, I gave this all up to God, and God takes care of all that. So whatever God puts on your heart to help with support, I'm not one of them patriots like a lot of people talk about out there. I do have a business, and I do that through Patreon, so I want to thank all of those that are on Patreon. God bless you all. Have a wonderful